33 hours. That's how long it took the FBI to identify a suspect after a political assassination in Utah. 48 hours for a separate case in Minnesota involving a state senator and his family. A senator brings both of those numbers up, back to back, congratulates the director on the speed, and then pivots straight into asking why a completely different investigation has taken decades without the same kind of resolution. That's a real rhetorical move, and I think it's worth actually testing instead of just reacting to it, because comparisons like this are persuasive whether or not they're actually fair. And the only way to know which one this is to slow down and look at what's actually being compared. We've got three threads today: that response time comparison in full, a set of asylum statistics that get thrown around a lot but rarely explained, and a specific legal claim about which court actually controls what can be released from a sealed proceeding, because I think people are getting this one wrong in both directions online. Fast version. Kennedy's hearing with Patel covers a lot of ground: polygraphs, past FBI politicization under prior leadership, the Black Book question we've covered before. Buried in the middle of it is this comparison, and it doesn't get nearly as much attention as the no one answer that follows it, but I think it's actually doing a lot of the persuasive work in that whole exchange, so it deserves its own look. Here's what's actually said, as close to verbatim as the transcript gives us. Kennedy asks whether the FBI, working with state and local partners, caught the person responsible for Charlie Kirk's killing. Patel confirms they have a suspect, 33 hours. Kennedy then brings up a separate case, months earlier, an assassination involving a state senator and his family in Minnesota. Asks if that was solved within 48 hours too. Patel confirms that timeline sounds right. Kennedy's response: "Congratulations. Sometimes we miss the forest for the trees. Good work." Then, a beat later, he asks whether the person responsible acted alone. Patel's answer is careful, says it's an ongoing investigation, he can't speak to state charges specifically, but confirms there are people still being investigated and interrogated connected to a chat room referenced in the case, and yes, others could have been involved. So, worth pausing here before even getting to the pivot, because that "did they act alone" answer is genuinely more open-ended than a lot of coverage treats it. Patel isn't saying, yes, one person, case closed. He's saying the investigation into potential additional involvement is still active. That's actually a meaningful admission on its own, separate from anything about Epstein. Now, the actual pivot. Kennedy uses those two fast resolutions to set up the frame. The system can move with real speed when it wants to. Then, later in the same hearing, gets to the Epstein question and gets the no credible information answer we've covered in previous videos. Here's where I want to actually slow down and test this, because on the surface, it's a genuinely compelling comparison. 33 hours here, 48 hours there, decades of nothing on this other case. That contrast lands hard emotionally. But emotionally landing and being a fair apples-to-apples comparison are two different things, and I think it's worth being honest about why. An assassination with a living suspect, physical evidence at a fresh crime scene, immediate forensic leads, and enormous public and political pressure for instant results is a fundamentally different kind of investigation than building a prosecutable case against additional participants in a trafficking network that operated in secrecy specifically to avoid detection, using non-disclosure agreements, private property, and, per multiple hearings, a legal environment shaped by a lenient 2008 plea deal that limited what evidence could even be gathered in the first place. Those aren't comparable investigative challenges just because they both involve the FBI. That doesn't mean Kennedy's frustration is unreasonable. Genuinely, I don't think it is. Decades without additional charges beyond Epstein and Maxwell is a real, fair thing to be frustrated about. But the FBI can move fast when it wants to doesn't automatically mean the slower pace here reflects unwillingness rather than a genuinely harder evidentiary problem. Both explanations are available. The comparison alone doesn't settle which one's correct. Small thing worth flagging on its own because it's easy to miss in the middle of that exchange. Patel references an active investigation connected to a specific chat room with multiple people still being investigated and interrogated. That's a specific, concrete detail about the Kirk case that doesn't get picked up again anywhere else in this hearing. If you're following that case specifically, that's actually the more useful thread to track going forward, separate from anything about Epstein. Completely different hearing now. Chip Roy walks Bondi through a set of immigration statistics before getting to his Epstein questions, and I think these numbers deserve their own honest check because they get repeated constantly without anyone explaining what they actually measure. Roy cites a backlog growing from roughly 1.5 million cases to nearly 4.2 million between the start and end of a prior administration. Bondi says that sounds about right, but doesn't have exact figures memorized. He then cites asylum grant rates, 14% in one fiscal year, 12% the next, and average case completion rates under the current administration, around 65,000 a month, described as the highest in at least a decade. Here's what's actually confirmed versus what needs context. The backlog growth and the low grant rate percentages are the kind of figures that come from EOIR's own published data, the Executive Office for Immigration Review, which is a real, existing part of DOJ with actual public statistics. Bondi doesn't dispute any of these numbers. She just doesn't have them memorized to confirm precisely on the spot, which is honestly a pretty normal thing for an attorney general not to have memorized live in a hearing. What needs more context, a low asylum grant rate doesn't automatically mean claims were fraudulent, which is sort of the implication in how Roy frames it. Asylum law has a genuinely high legal bar. You have to establish a well-founded fear of persecution on very specific protected grounds. A huge number of cases can be denied because they don't meet that specific narrow legal standard, without those cases being fraudulent at all. Genuine hardship that doesn't fit the asylum category's narrow legal definition gets denied constantly. That's just how the statute is written, not evidence of bad faith filing. The $65,000 a month completion figure is presented as a straightforward positive, clearing the backlog faster than ever. Worth adding one honest caveat. Completion rate alone doesn't tell you the outcome of those completions. A case can be completed through a grant, a denial, or an administrative closure. And a rising completion number paired with already low grant rates could mean faster processing toward more denials, which is a genuinely different story than just efficiency, even though both descriptions use the same underlying number. Neither reading is confirmed or denied directly in this exchange. It's just worth knowing the number alone doesn't tell you which story it supports. Back to something we've touched on before, but worth nailing down precisely, because I think it gets misstated constantly in both directions across basically every video anyone makes about this. The legal question: who has authority to release grand jury material? Federal grand jury secrecy is governed by Rule 6E of the Federal Rules. The core secrecy obligation binds the government, prosecutors, grand jurors, court staff, far more strictly than it binds an individual witness describing their own testimony afterward. A witness generally can talk about what they personally said. That's confirmed, cited directly by a federal judge in testimony referenced across these hearings. But, and this is the part that gets flattened constantly, the transcript itself, the official sealed record, is a different matter entirely. Unsealing that requires a court order, and courts apply a real specific legal standard before granting one, weighing public interest against the traditional strong presumption of grand jury secrecy, which exists for genuinely legitimate reasons: protecting witnesses, protecting people who are investigated and never charged, preserving the integrity of ongoing proceedings. So both of these things are simultaneously true, and I think that's the part that resolves a lot of the confusion. A witness can be free to discuss their own testimony from memory, while the underlying sealed transcript can still legitimately remain unavailable to the public, because those are governed by different rules with different standards. When Patel says his testimony was released and a separate court denial of an unsealing request exists in the same year, those aren't automatically contradictory. They could simply be describing two different things: his own public account versus the sealed official record. Whether that's actually what happened here isn't clarified anywhere in what we've seen, but understanding the legal distinction at least tells you what the honest, open question actually is, instead of treating it as a flat contradiction or a flat non-issue. Real fairness check, quickly, on all three today. On the response time comparison, Kennedy's frustration about the pace of additional Epstein-related charges is legitimate, regardless of whether the comparison itself is a clean one. Fast resolution of a different kind of case doesn't prove slow resolution here reflects unwillingness rather than genuine evidentiary difficulty. But it also doesn't disprove it. The comparison raises a fair question even if it doesn't answer it. On the asylum numbers, Bondi confirming figures she doesn't have memorized in real time in a fast-moving hearing is a normal human limitation, not evasion. And Roy citing real EOIR statistics is legitimate. The caveat about grant rate context doesn't mean the underlying numbers are wrong, just that the story built around them needs the extra legal context to be fully fair. On the grand jury question, if Patel genuinely meant his own public account rather than the sealed transcript, that's a completely defensible, legally accurate thing to say, and the appearance of contradiction may be more about imprecise phrasing in a fast hearing exchange than an actual attempt to mislead. Investigators who work fast-moving violent crime cases will tell you directly, cases with a living, identifiable suspect and fresh physical evidence resolve on a completely different timeline than cases requiring you to build corroborated evidence against additional unnamed participants in a network that actively worked to avoid documentation. That's not spin, that's just how casework difficulty actually varies by case type. Immigration law practitioners will tell you low asylum grant rates reflect in large part how narrow the legal definition of asylum actually is under the statute, not, by themselves, a measure of how many claims were made in bad faith. And federal criminal procedure specialists will tell you the gap between a witness can discuss their own testimony and the sealed record can be unsealed is one of the most commonly confused distinctions in this entire area of law. Genuinely, even experienced attorneys get this wrong in casual conversation sometimes. The response time thread matters because it's a reminder that comparing two different kinds of investigations, even with real numbers on both sides, isn't automatically a fair comparison. That's a useful skill for reading literally any news story that uses, well, this other thing got solved fast, as an argument. The asylum thread matters because immigration statistics get weaponized constantly, from every direction, and knowing that a denial rate measures legal standard fit, not fraud, protects you from both overreading and underreading those numbers wherever you see them next. And the grand jury thread matters because it's directly relevant to anyone who might ever actually serve on a grand jury themselves. Knowing the real boundaries of what you could or couldn't discuss afterward is genuinely useful, not just abstract legal trivia. That's today's 3. Subscribe if you want the next one. Drop below. Do you think the response time comparison Kennedy made was fair or apples to oranges? Talk soon.